Chapter 1 covers English legal system. And how important is English legal system in terms of numbers of questions? So let's look and see how important material from this chapter is in terms of numbers of questions. And looking at the grid, you can see the practice of the examiner has always to be having a question on English legal system, always actually question 1 in the paper, and it is a guaranteed question. In the past, it's also always been a knowledge-based question. And I'm pretty sure that that will continue because English legal system doesn't lend itself to being examined through scenario questions. And I'm now going to give you just a little bit of an introduction to the topics before we hit them in detail. And I've summarised the whole of the English legal system by saying that the role of the courts, that's the judges, is to decide cases by interpreting and applying the law. So what is this law that the judges are interpreting and applying? What are the types of law? And we'll find when we get to it that there are 2 types of law. There is the criminal law and there is the civil law. So far as your syllabus is concerned, the majority of the legal topics within your syllabus are an aspect of the civil law. And that is why, when we go on to the next area, the courts, we concentrate on the civil courts. We do a little bit on the criminal courts, but the detail is on the civil courts. I then ask, are there other methods of settling civil disputes apart from going to court? And the answer is yes. Actually, there's quite a number of different ways of settling civil disputes. Perhaps the most common is the parties get together and simply come to an agreement. They make a compromise. We call that settlement out of court. You may have heard of things also like mediation and arbitration. But the only alternative method of settling disputes, which is within your syllabus, is tribunals. So that's what we'll be looking at. Well, whether a dispute is settled by a court or in a tribunal, it must be settled according to the law. So, what are the sources of law? Where does the law come from? Or, to make it more simply, who makes the law? Well, you've probably heard of Parliament as a maker of law. And the law that they make, it's called legislation. Or, another word for legislation, statute. So if I say something is statutory, all I want you to think of at this stage is that yes, Parliament had a hand in making that. The other type of law we'll be looking at, the other source of law, is case law. That's law developed by the judges as they are deciding cases in the courts. And we'll be calling that, quite commonly, we'll be calling it common law. And all I want you to have a view of at the moment is if I say, and that's a common law rule, you think, ah yes, it was developed by the judges in the courts. The next topic, the doctrine of judicial precedent, a very, very technical topic. It's looking at a lot of detail at exactly how judges go about deciding disputes in the courts. The next topic, statutory interpretation, is also very, very technical. Parliament makes statute, but it is for the judges to apply it in the courts. And we've got to look at the rules they use to interpret the words of Parliament. Then the final topic, the impact of the Human Rights Act on all the above topics. So that last topic impacts on all the others within the English legal system. So let's go into our first matter, the civil law and the criminal law.